My name is Martin Weda, and within the framework of the Chair of Culture for Peace and Human Rights at the Faculty of Social Science of the University of Buenos Aires, we will be holding the conference Profound Reflection and Unjust Convictions, Current Strategies for Research and Promotion. In this event, we will have the opportunity to listen to the valuable contribution of the speaker well versed in the subject. The conference will be broadcast on various digital platforms where the audience can listen and ask questions, which will later be addressed to the speakers. Firstly, we will have the participation of Dr. Daniel Medwed, Professor of Criminal Law at the Law School of Harvard University, United States. Professor Medwed is a founding member of the Board of Directors of the Innocence Network, consortium of Innocence Project Worldwide, and a former chairman of the board of the Rocky Mountain Innocence Center. He is currently a member of the board of directors of the New England Innocence Project. Professor Medwed has also received numerous teaching awards through his career, including a teaching and mentoring award while serving as a visiting professor at Harvard Law School, and students have selected him 7 times as their graduation speaker within the aforementioned most famous faculty of the planet. Likewise, we will have the participation of Luis David Fernández Zambrano, current professor of director of the Chair of Culture for Peace and Human Rights, the Faculty of Social Science of UBA. He's the author of numerous books and articles related to legal, constitutional law, labor law, human rights, education law, and culture. He currently works on launching Adolfo Pérez Esquivel Nobel Peace Prize in the search for peaceful and democratic solution to the various political and educational challenges of the modern world. I would like to note that Professor Daniel Meadows will have 25 minutes to present this insightful contribution on the subject, and then Luis David Fernández Zambrano will have a similar amount, approx, of day to make his contribution or express his opinion on the matter. Dear Professor Daniel Medwed, you have the floor. Thank you.
Thank you, Professor Weda and Professor Fernández Zambrano. My apologies for not speaking Spanish very well, but I do think that in many respects, doing wrongful convictions work is a little bit like the tango in Argentina, right? Because it's about sadness and nostalgia and lost love. Because in many respects, people who are behind bars for many, many decades have a tremendous amount of nostalgia for their past, a lot of sadness, and have missed out on opportunities for love and friendship. So I don't know that much about Argentina, but I do know about the tango, and I'm honored that you invited me to join you. My passion does relate to doing research and work in the area of wrongful convictions. And please let me know if I'm talking too quickly. I do talk quite quickly. The area of wrongful convictions, my interest comes from a deep-seated belief that the hallmark of a civilized society is the extent to which we protect our most vulnerable, our most marginalized, our poorest members. And if we don't give the most vigilant defense to those on the margins, those who are vulnerable, it might be what's called a slippery slope, a short trip to the erosion of rights for everybody. So when I first started doing this work, I used to be a criminal defense lawyer in New York, handling regular criminal cases for poor defendants in New York City. And then I became interested in wrongful convictions, investigating and litigating claims of innocence by New York prisoners. And my mother-in-law, who comes, many great research ideas come out of opposition to one's mother-in-law, I think, at least for me. And my mother-in-law comes from a very conservative part of the United States, the state of Nebraska. And when I told her I was doing work in the area of wrongful convictions, that innocent people are convicted, her first response, that couldn't happen in a civilized society. Innocent people aren't convicted. And then I showed her some of the data. More than 375 innocent people have been convicted and freed through DNA testing, through science, proven that they didn't do it. And about 3,000 other people have been exonerated for other reasons. She looked at those numbers, which are quite sobering and a sizable data set, and she said, well, maybe it happens sometimes, but surely there are endless appeals, endless opportunities to correct those errors. And my response was no. In the American legal system, I'm not sure how it works in Argentina, but I'd love to hear from you, Professor Fernández Zambrano, later about this. In the United States, our trial is the hallmark. That's where guilt or innocence is adjudicated. There's a presumption of innocence at trial. And after trial, then there is a presumption of guilt. It becomes incredibly difficult to reverse that presumption of guilt after it's been entered. The famous story of Sisyphus pushing a boulder uphill. I imagine it's a story that is known in Argentina too, right? The Greek story of Sisyphus. That's what it's like to try to overturn a wrongful conviction once the trial, the boulder from trial, has come down the hill. In the United States, there is what's called a right to a direct appeal, but you can't bring any new evidence up during that process. You are constrained by what happened at trial. And then there are a couple other post-conviction remedies that are available that have a number of constraints. And then there's something known as clemency, which I believe is also something that is available in Argentina and many countries in Latin America and South America. But the president or the governor, they're usually very reluctant to grant clemency to people who claim to be innocent. So what I'll do today, I'll do three things. I'll basically respond to my mother-in-law because those are the questions that a lot of scholars and others have raised. First, why are people wrongfully convicted in the United States? First. Second, why is it so hard to free them after they've been wrongfully convicted, even when you found new evidence? And third, what are some strategies for solutions? Okay, so I'll take those three things in turn. First, why are innocent people convicted? The term wrongful convictions is a little bit of a misnomer. It's a bad term because a lot of convictions are wrongful in the sense of unjust. Someone who is convicted because of their race or their gender or their ethnicity or their sexual orientation, that's a wrongful conviction. But wrongful convictions in the way that I'm using it and the way that a lot of scholars use it in the United States is about the conviction of a factually innocent person, someone who didn't do the crime, yet has been charged and then is convicted. Here are the major factors. The number one factor when you look at documented wrongful convictions in the United States, eyewitness misidentification. Eyewitnesses simply make mistakes. Contrary to the movies, right? Crimes occur under suboptimal conditions. They usually occur quickly, at night, they're by dint of surprise, and eyewitnesses are not in a good position to evaluate what is happening. And that original mistake might occur. After that original mistake occurs, there are a series of other mistakes in the system that could perpetuate the error. In the United States, the way that we do a lot of eyewitness identification procedures, and I'm not sure how it's done in Argentina, is we have what are called lineups or photo arrays, where an eyewitness will look at 6 photographs of people who resemble the description of the offender, or look at 6 people in a line and evaluate who is the person. What happens when you're given a choice like this? What we all do is we take the best option. We choose the option that looks best, not necessarily the right option. How many times have you gone to a restaurant and instead of being asked, what would you like for dinner? And you just say, the perfect thing you'd like for dinner In Argentina, maybe steak. I don't know. Whatever it might be, whatever you say. You're just given a list of 6. You end up picking the one that's best, but maybe not what you really want. What happens is you make what's called a comparative or a relative judgment. Who most closely resembles the perpetrator rather than making an absolute judgment. So eyewitness misidentification appears in about 70% or more of documented wrongful convictions. Another factor, false confessions. People sometimes confess falsely to crimes because of cognitive or mental deficits, because they might be underage, they're juveniles, and they don't understand what's going on. Am I talking too quickly, Professor Fernández Zambrano, a little bit? Too fast?
Yes, continue.
Continue, it's not too fast?
Yes,
Okay.
yeah. Go.
Go. I only have 25 minutes, so. False confessions occur when the police ask a series of questions of a suspect under very arduous and stressful conditions. And if the suspect is potentially cognitively or mentally impaired or very young, they might say whatever it takes to get out of the interrogation room. And they think that they can save the argument for another day. They can correct the information later. I often explain to my students, how many of you have gotten into a dispute with your partner and you've said, you think your partner was wrong, but you are tired and you want to go to sleep. And so you say, you're right, partner, I made the mistake. And you think the next day you will revisit the argument and you will win. How does that go for you? Not very well. It never goes well. When you have that sort of short-term thinking, I'll get out of the situation now, I'll admit to doing something bad and I'll explain it later. It doesn't work well in the criminal justice system either. A third factor why these cases happen, police or prosecutorial misconduct. In the United States, there are some bad apples. There are bad prosecutors, bad police officers, but I think there are very few of them. I actually think there are very few. Instead, I think that there are good people who have incentives to make bad decisions because of pressures to make arrests, because of pressures to get confessions, because of pressures to get convictions. In an area of law where metrics are very hard to find, how do you determine whether a police officer is doing a good job? How do you determine whether a prosecutor is doing a good job? Regrettably, arrests and convictions have become a proxy for success, and they shouldn't be a barometer for success. There are unique professional, political, and practical reasons for this. A fourth factor relates to forensic evidence, or what some people call junk science. So many of us who are lawyers, who are social scientists, like Professor Fernández Zambrano, I wasn't very good at math. My mother is very mad that I was never a doctor or a scientist. But many of us revere scientists. We revere mathematicians. We don't feel equipped to challenge what they have to say. The problem is a lot of forensic evidence in the courtroom, even fingerprint evidence or other forms of evidence, isn't necessarily scientifically valid. Yet we let the jury hear about it and they overvalue that evidence, even though it might be flawed. Two other factors that we see in a lot of these cases, we see the use of what are called incentivized witnesses, informants, witnesses who are testifying against a defendant in exchange for favorable treatment. You might lie if you're promised a benefit for your testimony. And lastly, ineffective assistance by defense lawyers. In the United States and in many countries, defense lawyers for indigent clients, for poor clients, are under-resourced. They don't have enough resources to do a very good job. So a lot of wrongful convictions relate to situations where their own lawyers fail to investigate the case properly. So that's why mistakes often happen at the beginning. Why does it take so much time to free people on the back end? I mentioned that we have about 375 documented DNA exonerations in the United States. People were wrongfully convicted, biological evidence was retained from the crime scene and later tested, and that test excluded the defendant as the perpetrator. We also have several thousand other cases, non-DNA cases like that. Why did it take so long, even if you have good evidence? Part of it is, in the United States, there is no right to an attorney after your trial and your first appeal. And most of these cases are litigated through various post-conviction proceedings that occur after the regular course of the litigation. So what happens is people have to handle those for free. People like me who work for law schools, or lawyers who are donating their time to work on these cases. There just aren't that many people to do it. Another reason is that the rules of this post-conviction process are very deferential. They defer considerably to what happened at trial. It is very hard to get a judge to change her mind, even if you have lots and lots of evidence to this effect, okay? So the last thing I'll talk about, because I only have a few minutes, the last thing I will talk about relates to potential solutions. So if you think the first problem, why are people wrongfully convicted? The second problem, why does it take so much time to free them? Then we can think about solutions in essentially three different ways. The first, and this is why Professor Ueda and Professor Fernández Zambrano, I'm so happy you invited me. The first solution really is education. You're both educators. Many people who are participating are involved in education. And we know that the first step to making our society safer and better is education. In the United States, there is a saying, a famous saying, I don't know if it's popular in Argentina, that sunlight is the greatest disinfectant. That if you put sunlight on a problem, the sun will heal it. And of course, the sun does destroy disease, but sunlight also exposes problems in the criminal justice system. So the first thing to do is we study these issues. We talk about them. We write about them. We make sure people understand them. The second thing we can do, and there's often a debate in law reform, and I'm sure in Argentina it's a similar debate. I call it the debate between evolution, small incremental change, versus revolution, dramatic change. And to some extent, we are all different in terms of whether we're evolutionaries or revolutionaries. But some suggestions could be evolutionary. Let's change some of those factors that lead to wrongful convictions at the beginning. For instance, eyewitnesses make mistakes. We could have juries instructed and judges instructed about the problems with eyewitness misidentification. We could change the procedures in which people identify suspects. Instead of having a lineup where you compare 6 people against each other, it's called a simultaneous lineup. You could have what's called a sequential lineup. Have one person go before the eyewitness, and the eyewitness says yes or no. Then a new person comes in, yes or no. You would make an absolute judgment about whether that person is the perpetrator, not a comparison. We can improve police interrogation tactics to get rid of pressures. We could improve the validity and the verification process for forensic science. We could provide better funding to defense lawyers. So those are all evolutionary suggestions. And we could improve procedures on the back end to make judges more open to looking at claims of innocence based on new evidence. However, let's also think about revolutionary ideas. In the United States, our system, which is very different from Argentina, is based on an adversary system where we think that if you pit the defense lawyer against the prosecutor in a fierce battle, the truth will prevail. And the judge is a little bit like a referee in a football match, right? Soccer, we call it soccer. You call it football, right? They don't intervene very often. And when they intervene, what happens in a football match? They get booed. They get yelled at by the fans. But the problem is that idea that the truth prevails through a fight is a very dated idea. And it's not necessarily an accurate one because it's not a fair fight. The prosecutor has much greater resources than the defense lawyer. So we could change this. Why don't we have more intervention by a judge? A little bit more like the civil law system where judges are actively involved in the trial process. Also, for the post-conviction process, instead of just having these cases go to the regular courts through our regular court processes, we could set up a special innocence commission, a group of judges and ex-prosecutors and ex-defense lawyers with expertise in this area, an independent agency that could investigate these claims and refer them to the courts ultimately. So as we think about advocacy strategies, given what we know, I think it's important to combine evolution with revolution because they can work in tandem to get us to a better place. So without further ado, I think that's pretty much my time is up. I will turn the floor over to Professor Fernández Zambrano.
Excellent. Thank you.
Thank you.
For your presentation, Professor. Professor Luis David Fernández Zambrano, you have the floor.
Well, hello. Good afternoon. I hope you are way along with all your loved ones. I truly am honored for me to have the opportunity to present alongside Professor Daniel Medwed on a topic too relevant to reflect on the errors on judicial system and gradually build a fairer, more equitable and supportive world. Firstly, I would like to begin by the recalling and aware of the universal literature whose reflecting fruiting in the preventing criminological field has extraordinary relevance within the contemporary world. Yes, I am referring primarily to the renowned work entitled Les Miserables by the celebrated French writer Victor Hugo, published in 1816 2 years, where the character, the Jean Valjean, has philosophical and legal epicenter to think about the nature of the injustice inside and the outside the courts. By systematically contemplating the tale and the leg on the person to step break for dire the jam is sibling and receive and accessible the judicial sentence and think that the principle of legality ignored enough to understand the limit of justice. The same celebrated French writer mentioned this aquarity, the dark classic of the universal literature, along as the three problems of the age, the degradation of the man by poverty, the ring the woman by starvations, and the worldling on the childhood, the by physical and spiritual night, are not solved as long as in the certain region social affliction shall be possible. In the other words, and from a yet more extended point of view, so long as ignorance and misery remain of our books likes in the cannot be useless. This scene, the coming from the world of the literature art, served to analyze the various underlying causes that also hide the unjust deliberations is shocked by the course. Honestly, these are causes that opportunity still survive the relentless passage of the time of the transcends and language barrier. Their philosophical legal discussions of Radbruch and Leonard Hart, Eugenio Boulevin, John Rawls about the justice in the German and British and United States in the 20th century. In the same vein, I must declare the various judgments in the criminal matter can acquire the status of the fair of the unfair due to multitude of endogenous and exogenous factors, governed by a special and temporal principle. On one hand, it is profoundly relevant to mention that in the many countries of the American world, the various political constitutions inspired by the theory of the separation of power, the forward of the time of the John Locke and Oliver Cromwell, have decided to design their government architecture in three powers: executive, legislative, and the judicial. In this later type of power, it is instinctively determine whether a judgment and the fair or unfair. However, we must consider that judicial institutions are composed and constituted by a set of the social agents whose decisions in criminal matter are largely shaped by circumstances, reality to moral principles of each have the evidentiary means presented to convict the subject of the investigation, the veracity of said evidential means, the rule of law, or unknown in many countries, the principle of legality, the moral and ethical quality of the experts, and the social and political pressure that can inexorably lead to existence of maleficence. In the sense vein, I wanted to mention an hypothetical situation among the men that exist when configuring unjust punishment agents in sittings. A magistrate has a good moral and intellectual upbringing, back in the expert involved in the matter to clarify the leak of the accused on the correct and decide to submit false evidence. Based on this evidence, the magistrate representative of the prosecution's attempt to argue plea. Obviously, there may be argumentative struggle between two experts to determining who is correct, but in the meantime, preventive detention is adjudicated to the alleged perpetrator of the crime. In the end, it's proved that the evidence present by the public ministry expert is false because the same expert decides to admit their error and became falsification. After the incident, they had the determinants to annul the custodial sentences, obviously an unjust penalty, and order the immediate release of the defendant. This later hypothesis is the real expressions in the legal case brought against the Martin Guillermo Morales Zambrano for the commission of a sexual freedom crime. For the renowned prosecutor named Albert Pinedo Muñoz, religion of dubious evidentiary means presented by the expert who later disavowed his own evidentiary minds was prolonging the process seeking to adjudicate an unjust penalty. However, thanks to the sincerity and honesty of the medical expert, that judgment could be transformed into a fair and realistic judgment. However, a second feasible situation arises in the scenario where the magistrate has the case on the person whose preventive detention was triggered by unjust sentences. As the crime attributed to them is not related to the typicity of the criminal code of the entire country. However, despite the lack of the solid evidentiary minds and the inconsistent legal grounds, the competent magistrate decide to uphold and sentence that side to imprison the involved person Obviously, this is representing and crime on malfeasance in Latin America is non-lawful. And this goes beyond the political affiliations on the accused because it has to with the technical legal condition in which the procedural rights of the accused were violated. This latter hypothesis finds its real expression in the case of Mr. Pedro Castillo, who during his term of office maintained good commercial relation with the current president of the United States of America, Joe Biden, as evidence in many photos from the United States Embassy in Peru, demonstrating the fraternal friendship between Pedro Castillo and current president of the United States. She is accused of committing a rebellion offense, but according to article of the criminal code of his country, for that criminal figure to be configured and armed, arising in is needed, which never occurred. It's essential to highlight that the Secretary of State of the United States, Antony Blinken, is also a graduate of our beloved Harvard University, and from his notable global authority, he decided to publish a report on the Peruvian reality regarding human rights, considering that this country received succeeds from the United States. The file in Peru begins with the record of the 49 protesters killed during classes with those with law enforcement and lethal and excessive use of force, denounced by the Inter-American Commission on Human Rights, particularly severe in regions with a majority indigenous populations. However, maliciously and falsely, he has the label and the communistic and completely false argument, socially to fuel social hatred that allows the legitimacy of the unjust penalty. Is it necessary to specify that the prosecutor, Patricia Benavides, was responsible for driving unjust penalty in the Peruvian lands against that gentleman is prosecutor who has suspended by the National Council on Justice for being involved in very severe corruption processes. It is important to clarify here that I don't oppose the idea of investigating Pedro Castillo back to a judicial process that respect constitutional guarantees and about all due process in criminal matters. Obviously, that still does not occur within the courts of that Latin American country, according to many experts in human rights worldwide. And the third factual situation relates to condition and freedom of expression for independent journalists and the laws that seek to promote a culture of censorship in the Peruvian lands, and above all, to promote reprisal against the journalists who advocate an heterodox position in relation to discourse of the hegemonic media. A few days ago, I was in conversation with extraordinary friends and colleagues from the John F. Kennedy of the government in Harvard University, named Pippa Norris, who highlighted the importance of the fighting against the culture of censorship to promote freedom of expression and the defense of democratic values. However, in Argentina and Peru, there are legal and political reprisals against heterodox the voices of official journalists. In Argentina, there are the famous case of the journalist Baby Chocopar, who's receiving an unjust penalty for his realistic opinions in the face of postmodern and identity-based discourse. And in Peru, this later hypothetical situation become a reality with the case of Luis David Fernández Zambrano. Yes, indeed, in addition to being the director of the Adolfo Pérez Esquivel Chair at the University of Buenos Aires, I also dedicate myself to the noble exercise of cultural journalism. A year ago, I decided to interview a colleague from the University of Buenos Aires named Guido Croxato of literary topics. Back when he defended Pedro Castillo international tribunals, they immediately decided to exert pressure against me, creating in the hostile environment in my work, inventing false evidence and false witness against during my work stay in Peru, to the point and causing me to lose my hope in that country, with the complicity on the certain authority of the public ministry under the direction of Patricia Benavides, the former national prosecutor, Juan Antonio Fernández Llori, head of the National Authority for Control of the Public Ministry of Peru, and Nancy Mendoza Enrique, the provincial prosecutor who heralded of the repression against me, rating affecting my psychological and emotional situation. It was very sad because I had to experience firsthand how human rights are violated, something that in general from the chair of the University of Buenos Aires, Harvard University, University of Chicago, many can only feel as pressure, but not as direct protagonists. I remember that in those difficult conditions, I had learned to live on the less than $10 a week without neglecting my activities as director within the chair of the cultural activities of the human rights of the University of Buenos Aires, inspired by Mark Law for university teaching and the mystic of educational instructions. And due to those unjust conditions caused by the Palicio of the century against the journalists exercising the freedom of expression, I must mention there were also similar cases to mine, such as happened with the Supreme Prosecutor Berxaber Revilla, who had more than 13 years of brilliant service in the public ministry, demonstrating great efficiency. However, opposing a block of the administration of justice, they tarnish her admirable and honorable professional career with the words defamation and lies, causing her to also decide to return from that institutions. Bokok aus no first-hand what it means to fight against judicial injustice in the temporal context, our legal impunity implementing in this maximum splendor. I sincerely believe that it was the best test of the morality and love the teaching that it received in my entire life. Here is fundamental reason why the illustrious Secretary of the State of the United States government reality, pointing out the following in the aforementioned report. They document as that freedom of expression fast challenged in the context of the Wing report of attacks against arguments, especially in coverage on demonstrations. Various organizations, including the National Association on Journalists and the National Association of Journalists, recording a significant increase in intimidation toward the press, with 253 attacks against journalists from December 2022 to February. This would be equivalent to violating the First Amendment of the current Constitution of the United States of America. The true case among the many that they exist in the world and compelling examples on the various aspects we must consider. Judgments in the criminal matter to the operated the abstract, the merely of the paper, in the reality that factor the challenge formal legal principle and the rise to rights for malicious purpose versus by human in the their existence. The problem had much to do with the lack of the seriousness. Many magistrates, hackers, prosecutors around the world assign to their code of the ethics and above to their social responsibility. There exists and that segment constituted by the system that in the general fund their salaries and is a fundamental duty to defend democracy to ensure the general welfare. It's necessary to adopt a systemic approach to this judicial tradition of examining also aspects. Therefore, the social cultural approach is important, especially to examine the fundamental role played by prejudices and stereotypes within the legal and judicial world when issuing judgment. No only reasons behind unjust judgments, which my extraordinary colleague Daniel Medwed investigated from Harvard by fundamental in the organ parts of America. It is an important aspect, but also discrimination based on ideological, political, religious, sexual, or cultural motives. In the essential to return to ethics proposed by John Rawls, were pointing out that true liberalism consists of the seeking and respecting ideological diversity. Indeed, this gradually creates for tolerant system, less ideologically poison, and above all, with a more diplomatic culture. These systems are found not only the markets, universities, and agriculture fields, but also the judicial courts, which have the duty and issue judgment in the first, the second, and third instances, where freedom and legal principles to defend in the Constitution of the United States and the errors on the Constitution of courts of Cadiz or 812 years, such as those of Argentina, Chile, Peru, among the other currently in the force. Also important is international leadership that they always believing about the judicial dynamics, the virtues, the control in the world of the student back. In the event that punitive, the system do not function in the most correct way, the issue important pronunciation on the matter. As in the case with the United States Department of the States and the illustrious Dr. Anthony Blinken, likewise the participation on the citizens and university too from various parts of the world in creating digital network and the spaces for conversation were sitting affected by unjust convictions can shame their voices within like faculty to receive the guidance and address this complex problem. It's crucial to seek more reasonable solution to issues affecting civil liberty and democratic principle. Finally, on the other hand, it's crucial to priorities and simplification educations. prejudice for the within and the outside academic institutional frameworks, decreasing the interest to criminal policing and preventive modes, must have significant articulation with the elevation of the cultural quality within citizenship as system to improve democracy. Robert Dole, the renowned professor of the political science in the Yale University, to receive an honorary doctorate from Harvard University, a rec that for democratic practices to work better, a more enforced situations in needing one that makes more reasonable, intelligence, and empathetic decisions. The roles of journalists, media are also important, is promoting the dissemination of this aspect and creating a mental and consciousness quality in the citizenship to always keep them alert to such the judicial activity that tram on the validity of the human rights and civil liberties. The famous intellectuals, Newton Mino, father of my extraordinary friends and colleague with Martha Mino, forming dean of Harvard Law School, born in May in 1916, 1 year, that television was becoming vast wasteland, and therefore is the necessary to restore in educational and cultural role to educational content. While property rights are important, so are cultural and educational rights, especially when the health of democracy and the defense on civil liberties are at stake. I believe that the penal system must humanize its agents, but also regulated the human dignity plagued by brotherhood, solidarity, and hope. I hope these noble comments serve to broaden the perspective on the matter and, above all, the create better the future focal points on legal conversation, not only in America but on the other continents, to build a world that erases the darkness of oblivion and sadness. Finally, I would like to take advantage of this opportunity to you, esteemed colleague with Daniel Medwed, extend my sincere and profound thanks to all my esteemed colleagues and now friends who work at the Harvard Law School for their wonderful emphasis, solidarity, and support in the difficult moments of my life since the last year. Her legal impunity prevailed in the Latin American lands with those remarkable humanitarian that has yours. They showed me that is worth all the pain in the world to continue feeding the fire of hope to build a much better, the fairer and more supportive the world for future generations. Infinite thanks. Thank you very much for listening.
Thank you. That was fantastic. Thank you.
Thank you very much, Professor Luis David. Now, during the course of your presentation, we have received some questions from students watching this live broadcast. I will mention the following to hear your opinions. First, how can we adopt current research and promotion strategies to more effectively address racial disparity in unjust convictions, considering the intersection of socioeconomic, cultural, and structural factors in the criminal justice system? How could the latest research in cognitive neuroscience inform and improve legal and defense tactics to prevent and correct unjust conviction, particularly when examining how cognitive biases and perception errors can influence judicial and jury decision. Each you will have 5 minutes to provide the appropriate response. Estimate Professor Daniel Medwed.
Great. Thank you, Professor Ueda. I'll be brief. Those are great questions. First, with respect to racial disparities, there's a concept in American research and law known as bias in and bias out. If the inputs into the system are fraught with bias, the results out of the system will be biased. So what we have to do is we have to change those initial inputs. So in the United States, what that means is we have to stop racial profiling in policing. Many of our policing tactics go into particular neighborhoods, what are called majority-minority neighborhoods, where people of color are targeted by the police in ways that are disproportionate and unfair. So the first thing we have to do is change the inputs through changing our policing. Relatedly, I think, and this ties into some of the cognitive bias comments I'll make in a moment. Relatedly, we have to change the composition of the decision makers. Professor Fernández Zambrano mentioned the sort of social, cultural context. And I think in the United States, we need more judges and more prosecutors who look like, who come from the communities, who share the same racial identity as the people who are being adjudicated before them. Because in the United States right now, it's incredibly disparate. We mainly have white upper-class men making decisions for people of color. That has to change. Now, in terms of the cognitive and neurological research, a few thoughts. One thing we know from our study of wrongful convictions is that cognitive bias is a huge part of this, both in terms of how the police investigate crimes, how judges adjudicate them, how prosecutors charge them. And the biggest problem is something known as confirmation bias or tunnel vision. Once the police or the prosecutors develop a theory of the case, they become very wedded to the theory, and it becomes difficult for them to look at the case from a different perspective. So one thing that we're talking about now in the United States is trying to set up structures so that people are forced to look at cases anew and to not just reevaluate their own decisions. Have different people review the decisions of the original decision maker, not just have yourself review your own decisions. So within prosecutors' offices, you could have internal units that are called conviction integrity units that will look at the cases and decide, without being attached or wedded to the case, decide whether it might be flawed. Confirmation bias is a huge problem. We need to make sure that people aren't wedded or stuck to their original theories, and that involves bringing in outsiders. Professor Fernández Zambrano, please.
Excellent. Thank you.
I am thinking recent advances in the cognitive neuroscience of the indelible insight into how the cognitive basis and the perceptual errors can influence the judicial decisions and jury verdicts. By better understand this underlying mechanisms, the lawyer and defender can develop the more effective strategy to prevent a correct wrongful convictions. First and foremost, it is crucial to recognize that cognitive biases are the inherent in human nature and can influence all stages on the judicial process, from initial investigation to final verdict. Therefore, it is essential to lawyer and defender to be trained in cognitive neuroscience to identify and mitigate the basis in their arguments and presentation before the court. For example, research has shown that implicit biases can affect the perception on witness credibility and interpretation of evidence. Lawyers can use the knowledge to implement standards that contract this basis, such as presenting additional evidence or utilizing expert testimony. Additionally, cognitive neuroscience can inform the development of the more effective interrogation techniques that minimizes the influence of devices, the weakness statements, and increase the accuracy of the testimony. For example, research of the memory and attention can help the lawyer formulate the question for maximizing the retrieval and accurate information and minimize memory contaminations. In summary, leveraging cognitive neuroscience in legal and defense tactics can significantly improve the ability to prevent and correct wrongful, the conviction, by providing and deeper understand and the underlying the cognitive process in the judicial system. By integrating this knowledge into legal practice, the lawyer and defender can promote greater justice and equity in the criminal justice for the building of the future for the humanity in the new millennium. Please, thank you. I'm sorry for the detours, algunos detalles técnicos de virus informático. Thank you very much.
Okay, Luis, thank you very much. Professor Daniel Medwed, Luis David Fernández Zambrano, we want to express our sincere gratitude to both of you for valuable intervention. Due to time constraints, unfortunately, you must conclude this academic event, which will serve to defend this reflection and contribute to the construction of a more conscious society with the aim of building a much better world. And next, I will give the final words to Professor Luis David Fernández Zambrano to conclude this memorial ceremony, essential for promoting a much fairer and more supportive world. Thank you very much.
Thank you so much. It was wonderful.
Very much. One moment, please. I would like to extend our gratitude to Professor Daniel Medwed for his tremendous willingness and the commitments and the contact us and well and the forthrighting and the esteemed honor. We send our best wishes for him to continue his impressive the battle for the justice of the innocent worldwide and to so seek a call on opportunity for building a better future for humanity. For here, we express our fervent desire to be visit in personally Sunday at Harvard University to greet him in person and continue conserving and dialoguing with him and other colleagues on these debating topics with that aim in the building of better world and continuing to outline new collaborative projects. Would you agree, dear friends and distinguished colleagues, Daniel Medwed? In advance, we wish do many congratulations about what success in the company of all your loved ones. Thank you for the opportunity.
Thank you so much. I look forward to future collaborations. Thank you.